What we're going to do today is that we're going to be talking about the European Court of Justice, what it does, and constitutionalism of the whole process of the European Union law. And then we will look at the preliminary reference procedure, how it works, why it came into being, and what kind of benefits it has, and how it functions basically. And then after the break, we will be looking at the doctrines of the EU law and the basic cases, the major cases about the doctrines of the law. So European Court of Justice, that's the common usage for the court. But after the Lisbon Treaty, it's basically referred as the Court of Justice. But no matter how you change the name, whatever it has been used for a long period of time, you will still be seeing the ECJ or the European Court of Justice in various web pages, literature, this and that. But it's now the Court of Justice of the European communities, basically. But we will be referring it as ECJ for the purposes of this course. But whatever you refer, I will be accepting it. So we are referring to the same court, the highest court of the European Union, basically. Court of Justice has a very critical role. It evolved over time as other institutions of the European Union. It started as a tribunal or a court, and now we can see that the court played absolutely a critical role in the European integration process. Why it played a very critical role? It's because it was able to use what we now call as a judicial activism. So we will be seeing what it is today. Judicial activism is what the ECJ did over time in terms of interpreting the EU law. It was able to take the vagueness of the role of the EU law and its role basically in the European integration process, and it used its powers in order to promote the European integration even further. So we see that especially in the 1960s, when there was a rise of intergovernmentalism with the empty chair crisis, it was the ECJ that pushed with its supranational characteristics and the decisions with the cases, the integration further. And we will see those cases as well today. And what are those cases? Court is composed of judges, and they are assisted by the advocates general. The judges, they were planning to limit the number of judges at a certain limit before the EU enlargement, the Big Bang enlargement basically, but it was not achieved. Now, equal number of judges for equal number of member states as most of the other EU institutions. So we now have 28 judges. This might change over time when there are more member states joining, but at this moment we have 28 judges. And they hear cases depending on different number of judges for different tribunals. So it can be 3 judges or 13 judges. It's always an odd number, not an even number, to be able to decide on a case, basically. So depending on the case, depending on the structure of the case, the subject of the case, the number of judges can differ. And the advocates generals help the judges in terms of, they prepare basically the cases and they prepare reports regarding the cases, and they prepare it for the judges and for to help them to decide on the cases. So they have that kind of a system. And how these judges are selected? The judges are selected according to their basic reputation. So each member state will be suggesting a judge. These judges should have a good reputation, and there should be no doubt about their impartiality as well, because the court's position is very critical, very important, and you cannot take the risk to put somebody. First of all, you have to be a very capable person, so these people can be judges, national judges who used to work in the field for a very long period of time, and there can also be professionals who are working either in public or in private sector for a long period of time too. But the critical issue is that they're capable people who should be able to handle such a position, such a power, but at the same time there should be they should be impartial. Why? Because the ECJ has supranational characteristics. Which means that it tries to promote the EU interest, and that's its role. So their independence in that respect, the judges' independence, should be beyond doubt. What does that mean? So they should be immune from any kind of public or private influence, because the decisions that are handled by the European Court of Justice are quite critical and important cases, and that can have either political or financial consequences. So these decisions that are being taken with the cases that the European Court of Justice handles either can make quite a significant impact on the pace or the route of the integration, but at the same time it can have implications either on the member states, or it can have implications on the businesses or the companies, for example. And these can be very big companies, multinational companies, or big European companies as well. So it's very, very important that the judges are able to make decisions without any kind of political or financial or business influence. So it's very, very critical and very, very important. The decisions of the European Court of Justice is final, so there is no appeal mechanism for this court. It's the highest court of the European Union. If you have to compare it with a national court, if you have to, then we can compare it to a constitutional court. So as the Constitutional Court's case is final, the European Court of Justice's case is also, the decision will be final as well. If you have to make a comparison in terms of the hierarchical structure, but what we can do is that, for example, the Civil Service Tribunal which will be deciding on the civil service cases of the European Union. You can appeal to the Court of First Instance, and if you're not satisfied by the decision, it's possible to use the European Court of Justice as a higher court for appeal. But the decisions of the Court of Justice is final. That's going to be the final authority after the case has been examined for appeal. What is the role? The role of the ECJ is specified by the treaties is that the Court of Justice and the Court of First Instance shall ensure that the interpretation and the application of its treaty law is observed. What does that mean? So it's quite critical that there is a uniform application and interpretation of the EU law, which means two basic roles. Interpretation and the application of the EU law. So the application and interpretation of the law is observed, and it also provides a forum for resolving disputes between the institutions, between the member states, and also between the individuals. So those can be, when I say individuals, it can be a group of individuals, or it can be companies, so it can be businesses as well. So between EU institutions, between member states, so they can resolve disputes between member states, or it is possible to resolve disputes between individuals. And I said individuals also includes companies, etc. It also has a function to protect the individual rights. So we will be covering in detail We have a specific week that we will be discussing about how the fundamental rights get into to the EU law, how it became part of the EU law. But you have to keep in mind that individual rights are also being protected by the European Court of Justice, although this has not been specified in the very early beginnings of the European integration process, that it acquired that role. It's kind of a spillover effect that it had to do this. And it takes actions against member states for failing to implement treaty obligations. So if a member state is not observing a treaty obligation, it is the European Court of Justice that can take an action against that member state. So there can be action against institutions in that respect for abuse of power. So the EU institutions might abuse their power in terms of applying or function in terms of their functioning. And it can also take actions against an institution for failure to act. It might, so the institution, an EU institution might abuse its power, or it might even fail to act, may not act at all. So that can also be an action that can be brought against that institution by the European Court of Justice. There are also actions against an institution that have been responsible for a loss for the individual. So some of the actions, it might act, an institution might act, but those actions might create a loss. It can be a financial loss, it can be some other type of loss that created for that individual. That's the European Court of Justice will take an action. And they also take references from member states for a preliminary ruling on the interpretation of the EU law and applying the community law with the courts of the member states. And I will go into details about how this preliminary reference procedure actually works. So we will get into that a bit more in detail. So I will explain what is preliminary ruling is actually and how it works and how it functions. And one other thing that we might be talking about, I said that there are 28 judges, and if any judge, they're selected by, they're appointed by the member states, and these are chosen from high-level judges from member states or highly competent lawyers who show impartiality, as I mentioned. And what happens is that in case of the colleagues, they think that there is a possibility of misfit to serve, so they don't think that that judge is no longer fit to serve for the European Court of Justice, it is possible to remove that judge from office. So just because they're appointed doesn't mean that they're going to be serving. So there is still, they're in this constant, in that sense, continuous monitoring from their colleagues as well. So, and also they have a president which is appointed for a certain period of time, and the president is basically representing the judges, doesn't necessarily have a very, in that sense, significant role apart from being the judge and representing the other judges as well. And what is important here is that the European Court of Justice has to make sure that the EU law is uniformly applied and implemented all around the member states. What is critical here is that we now have 28 member states. These 28 member states have different legal systems. They don't have a uniform legal system that is applicable in every single member state. Some member states have the constitutional law system, and some member states have the common law system. So even the legal systems are quite different. If you look at the British system, they have a common law system, and if you look at the French system, it has the constitutional system. So different member states have different law systems. So with these different law systems, obviously, when they have to implement the EU law, then they have to do it in a similar fashion. If they don't do this, then what happens is that there's going to be a distortion in terms of the application of the EU law. And if the distortion of the EU law in terms of its application, and it's not going to be possible to have uniformity within the European Union. And if you don't have the uniformity within the European Union, then you have the problem of not being able to have a single market, which is established by the Single European Act in 1986, to function effectively and efficiently. And there will be disruptions in that sense in the application of the certain common policies. So it's very, very important in that respect that you have the same rules that are applied uniformly in each and every member state. So that's why the European Court of Justice had this monitoring mechanism or the monitoring role to make sure that the uniform application of the EU law is observed in 28 member states. You have to keep in mind that it's not an easy task to do, because not only you have to make sure that the EU law, when I say the EU law is also composed of the treaties, the primary sources of EU law, and we will be discussing a bit more detail, and the secondary sources of the EU law, plus the case law also becomes part of the EU legislation. So this creates the body of the EU law in that respect, and the European Court of Justice has to make sure that the treaty obligations are observed in each and every member state uniformly. Any questions so far? About functioning. So let's look at how it is possible, because as you can imagine, with different legal systems in different member states, and the same treaty obligations have to be observed in these 28 different states. And the national courts are responsible in terms of applying the EU legislation and the EU rules. When their case comes to them, it should be their responsibility to make sure that the treaty obligations or the treaty provisions are actually respected. But think about it from 1957 onwards. So it has been a long process. From 1957 onwards, it was not necessarily an easy task for the national courts either, because it was in the beginnings of the European integration process. So they don't necessarily know how to interpret the European Economic Community Treaty obligations, the Rome Treaty. These national courts and the national judges, it's also a learning process for them as well. So it took time for them to be able to understand how these rules have to be observed and applied. And through this time, it was the European Court of Justice who developed certain doctrines. They interpreted themselves, basically, how to interpret the European treaty obligations. And one of the very critical issues that's been done is to have preliminary rulings. It's a very important mechanism that has been very useful both for the whole European integration process, but at the same time it has been also very, very important for the national courts as well, in terms of getting used to applying the EU law. Community law may arise in national courts through directly applicable provisions, for example, regulations, or applicable by national agencies, and it is necessary to have cooperation between the national court and the community courts. And this mechanism provides this kind of a cooperation. So what does that mean? For example, a case came in front of a national judge in a national court. And one case, they're not quite sure, the judge is not quite sure if that case has any relation regarding the European Community law or a certain provision regarding that community law, and the judge is not quite sure how to apply or how to interpret that provision, that article or that kind of issue regarding on that specific case. So what happens is that it's possible that that judge might refer that case with respect to that specific provision regarding the EU law to the European Court of Justice, asking the European Court of Justice's opinion on that particular matter. It's not a decision that the European Court of Justice will make, which means that the European Court of Justice, with the preliminary ruling, as the name suggests, is a preliminary ruling. It's not the final ruling. They're not deciding on the case, because it's up to the national court to decide on the case. They're just providing guidance, or they're just providing an interpretation of that particular provision regarding the European Union law. So they will be interpreting that provision regarding that particular issue, and they will be providing an explanation or interpretation for the national judge. And the national judge will then take the preliminary ruling, look at it, and apply that preliminary ruling on that particular case. Why is that critical? It is very important because, think about it, in the early beginnings, in the 1960s, we have 6 member states, 6 different legal systems, and 6 different national court mechanisms. And these judges trying to interpret a provision in the Rome Treaty, let's say, in a certain way. One judge might be interpreting, an Italian judge might be interpreting in a certain way, a French judge might be interpreting in a different way, and a German judge will be interpreting in a different way. So we will have different interpretations about the same provision from the Rome Treaty in completely different manners. This will create differences, divergences in terms of application of the EU law, application of the Rome Treaty, which will create various problems in the long term in terms of applying the functioning of the common market. So you have to have a mechanism that will ensure that same provision will be interpreted and applied in a similar manner in different member states, so that we will have a uniform application of the EU law, a uniform interpretation, and therefore a uniform application of the EU law. Is that clear? So this mechanism in that respect is very, very critical, especially in the very early beginnings of the European integration, when certain doctrines and certain rules or principles were still in the process of being developed. So that's why the judges were referring certain cases, and it's very critical that you have to understand that the European Court of Justice, in the preliminary reference procedure, in the preliminary rulings, they don't decide on the case on behalf of the national judge. It's still up to the judge in the national court to look at the specifications of the case and to be able to understand the details, this and that. It's just the interpretation regarding the EU law, regarding that treaty provision that's from the Rome Treaty, that they get the interpretation from the European Court of Justice. And they will be deciding accordingly at the national level on that particular case. This is called the preliminary ruling. And this preliminary ruling had a very, very important role because it ensured that, first of all, the European law is being referred and understood by the national judges, and it creates a cooperation mechanism between the national courts and the European Court. And it created a mechanism of, in that sense, interaction, and the EU law can be interpreted and applied and being transferred much more smoothly in that sense to the national level. So it had a double function. So its preliminary ruling procedure served several community objectives. First of all, as I mentioned, to achieve the uniform interpretation and application of the community law by member states. I made it quite clear. And secondly, establish a supranational community legal order. So you are making sure that it's a supranational system, that the national legislation has to be in line with the EU legislation, so the community legislation, basically. And third, to familiarize the national courts with community legal order. As you can imagine, in the 1960s, just after the Rome Treaty has been signed in 1957, the national courts or the national authorities are not quite familiar about this thing called the European Economic Community and the Rome Treaty and this and that. And fourth, to determine the situations in which the community law is directly applicable in the territory of the member states. So this direct applicability, we will be discussing, referring to certain cases, is also very critical and very, very important. The EU law is directly applicable, which means that the community legislation does not necessarily need a further, in that sense, a domestic procedure that will convert it to become a national law, as most of the cases international law applies accordingly. But the EU law has an exception, so that's why we call it a unique legal system and unique legal. It's quite unique. The whole process is unique. And fifth, shape the relationship between the national and the community law. So it basically created these relationship mechanism through these preliminary rulings. And the ECJ rulings made clear that the national courts should give primacy over community law order, which is incompatible with the national law. Any questions regarding this case? No? Quite clear? Very clear. Everything is incredibly clear. Okay, good. So let's look at these doctrines and cases, basically. What happens is that with the European Court of Justice, the cases that the court decides became quite critical and important and becomes part of the EU legal system. And that's why it's through cases over cases, certain principles, doctrines have been developed by the European Court of Justice. And over time, these doctrines are developed, and certain doctrines are being built over time with different decisions taken into actions. One of those very important cases that actually form the basic doctrines or the principles of the EU law is the Wangen Laws case. You can refer it as VGL to make it shorten. It's a case from 1963. So early beginnings of the European integration process, and as you remember, the 60s, the empty chair crisis and the Luxembourg Compromise. It's a process where it's possible to see the intergovernmentalism rising in the European integration. And that's why it was important to step in by the court and move the integration process a bit further through the decisions that it has taken. Wangen Laws is a company imported from Germany into Netherlands, a chemical substance. So just you don't have to remember the details of this case. What you have to remember is that the date of the case, basically the year of the case, is quite important. The name of the case is important, and the consequences of the case. So what kind of implications the decision of the case has made. But you don't have to remember the details, so please don't write it to me. I don't have to know, I know it already. And the Dutch authorities charged the company of an import duty. And as you know, at that time, Wangen Laws claimed that it was contrary to the European Economic Community Treaty. You're not supposed to be charging a duty in terms of importing a substance from one member state to the other member state. So basically they said, this is against the Rome Treaty, so something has to be done. And this was brought in front of the Dutch court, national court. And the Dutch court was not quite clear, so it referred it to the European Court of Justice, and the European Court of Justice, after examining the case, came up with a ruling, with a decision. And the decision was quite critical for us. The judgment of the European Court of Justice is one of the most important rulings handed out by the European Court of Justice, and the court said that the community constitutes a new legal order. So that's quite critical. What are they trying to mean by saying a new legal order? They're trying to say that at that time what is known is that there's the national legal order, the national law, and there's the international law, right? It's quite clear. And this is what has been seen. But what the European Court of Justice said with the Wangen law's ruling is that it's not as simple as international and the legal law and the national law. With the Rome Treaty, a new legal system, a new legal order has been created. And this is called the European Communities law, or the European Communities system, basically. It says that it's not only imposes obligations, but also confers rights on individuals independently of the legislation of the member states. So, independent from the legislation of the member states means whatever the national law is, independent from that national law, it doesn't only provide obligations, but it also gives them rights. It provides them rights. Not only obligation, but rights. But not only the member states, but at the same time to the individuals. This is known as the principle of direct effect. This was not clearly said. There is no such a thing as in the Rome Treaty. There is a principle of direct effect, and this means blah, 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 this and that. This is the interpretation of the court. The court interpreted in this way. The judges took the initiative and interpreted from the vagueness in that sense of the Rome Treaty, this principle. So the EC Treaty, which is the Rome Treaty, therefore capable of creating individual rights which national courts must protect. So the national courts has the obligation to protect those rights. It's confirmed the binding nature of the community law, and member states should internalize it without the need of national implementation measures within their domestic legal system. So let's try to understand what they're trying to do here. There are different types of legal systems, as I said. In some of the legal systems, it's the monolith versus dualist legal systems. Some systems argue that, like the monolith systems argue that if an international treaty or legislation has been signed, then there is no need of a domestic, in that sense, transfer or transition to the national system. It becomes automatically part of the domestic law. In the dualist systems, it is necessary that you have to, after like signing an international treaty and this and that, it needs a specific mechanism or procedure that you take that international legislation or international treaty, and you have to make sure that that international treaty is then interpreted in a certain way for the domestic legislation. So that's the dualist system. And some of the member states of the EU have the monist system, and some of the member states of the, at that time not EU obviously, the European Economic Community, had the dualist system. So different systems. So imagine that, because of the Rome Treaty is there, out there, it's been signed and been accepted. And some countries are automatically imposing all the rules and the obligations of the Rome Treaty directly, automatic to their national system. And some of them cannot do it because they need to have a medium-like mechanism that they have to process that legislation or the Rome Treaty or the provisions of the Rome Treaty to be able to make sure that it becomes part of the domestic system. So this will create difficulties, because this means that this is not going to be done automatically by each member state at one go. So what the European Court of Justice's decision says that doesn't matter what kind of a system that you have, it's a monist system or dualist system or this and that, it has a direct effect. The European Union law is directly applicable. So it doesn't matter what your national system is, dualist system, monist system, this and that. We realize that there are different legal systems in different member states. But at the end of the day, what we're expecting to do is to have that legal system to be directly applicable. So they don't necessarily would like to hear the excuses from the member states that I need a certain time and this and that, I have to make that disposition from this to that, and I require time. So this was eliminated with this principle, the principle of direct effect. Without such ruling, the uniform application of the community law by member states could have been be different to ensure, since some member states will follow the dualist principle and the dualist approach to international law, which do not have direct effect. So just because you sign a treaty doesn't mean that it's going to be directly applicable. You have to have some domestic national system to internalize that legislation. But some of the member states will directly make that international legislation become part of their national legislation. So you will have this differences between member states in terms of application. So these states will need to have some domestic measures to be able to do that. So this would have undermined the creation of a common market, as without the European Court of Justice's Wangen last ruling, the EC Treaty would confer individual rights on citizens of certain member states, but it wouldn't provide rights in other member states. And they have to eliminate that. They have to make sure that each and every member state, no matter what their legal system is and how they interpret the international law, will no longer exist, the differences. And why is that? Because in this case, the European Court of Justice judges said, don't refer the Rome Treaty as an international treaty. This is not a regular international treaty. And the system we established with the Rome Treaty is not international law. So what you have learned in the third year about international law, that's international law. And what the EU judges said at that time, obviously European Economic Community judges of the European Court of Justice said, this is a new legal system. This is a supranational legal system. And the EU law has direct applicability. It's directly effective. So this developed the principle of direct effect. Obviously, this is just beginning of a principle. With different cases, this direct applicability principle has been developed even further. It has been strengthened even further. So as you can imagine, in 1963, when they're writing a reasoning for the case, and when they're writing their decision for the case, I mean, they knew what they were doing, but they probably didn't know what kind of consequences this would have had. By just saying that it is creating a new legal order, basically they try to make a statement. You have to make sure that this treaties that have been signed in Rome 1957 is different than any other international treaty, because if we just leave it as a new regular international treaty, then it means that we will have to be at the mercy of the member states in terms of how they're going to be able to, make that treaty become part of their national law. And I think they just took the initiative, and they were brave enough, and obviously they didn't really have a mechanism to stop them. So this vagueness of the law, that's what we say, it was vague, and they didn't really have a provision that will stop them to do this, and they stepped even further in terms of pushing the integration. So basically they're declaring a new legal system in 1963 with just one case. We might just think that in 1963 it's just one case, a chemical substance being imported from one country to the other. It doesn't sound very critical to you, do you? I mean, So what, a critical substance that's going to be imported from one member state to the other one? And how are we going to be able to interpret this, Rome Treaty? It's a common market, so there should not be a duty. There should not be a tariff or tax or in terms of just importing that material. But not only that they're saying that this is against, they didn't just say that this is just against the Rome Treaty and there should not be any tax, but they took this a bit step forward and then they said it's an illegal order, it's no longer different. The Dutch authorities don't necessarily have the excuse, the national courts don't necessarily have the excuse just to say that we have to basically internalize the Rome Treaty. You don't have to do that, it's directly effective. So when it's signed, it becomes directly effective. And we don't necessarily mind what kind of a system you have to accept it as it is. So everywhere in the European Economic Community, these procedures should be applied similarly, accordingly. Because this is the European Community's law, and because this is not an international legal system that you used to know. And this is something new. It doesn't only bind the member states, but it actually has effects on the individuals, not only in terms of obligations, but in terms of giving them rights. They have rights. So that's why it was very critical. Any questions? Let's give a break then, right now.